Welcome to chapter 3. We're still in week 1 here, the second chapter. This is civil dispute resolution. Probably one of the most important areas of the law, only because through civil dispute resolution mechanisms, you can actually save a ton of money. The last thing you want to do as a business owner or even as an individual is end up in litigation. Litigation is extremely, extremely expensive, extremely time consuming, and there's a lot of uncertainty. So there are various mechanisms that we'll talk about to resolve disputes, litigation being one of those. So let's go ahead and get started with that. All right, so as I was mentioning, there are several ways to resolve disputes. We're going to talk a little bit about the court system, and in particular, the difference between the federal courts and the state courts. We're very unique compared to the rest of the world in that we have both a federal system and a state system. That also makes it very, very complex, whether you're a new attorney or somebody that's learning about the law. It makes it very complicated because we have the two systems with two different sets of rules, procedures, and so forth. They're actually different. We'll talk about jurisdiction, in particular subject matter jurisdiction and jurisdiction over the parties, or what we call in personam jurisdiction. We'll also finish up the chapter talking about civil dispute resolution. We'll talk about civil procedure, and then what we call ADR, alternative dispute resolution, and that's what I was talking about in my introduction to the chapter. We'll talk about mediation and arbitration, which are alternatives to litigation, which, as I mentioned, can become very, very expensive very quickly. So let's go ahead and start talking a little bit about the court system. Again, remember, as I mentioned, we have federal courts and we have state courts. So let's talk a little bit about the federal courts. Within the federal courts, we have two different types of courts. We have district courts, which in essence are trial courts of general jurisdiction that can hear and decide most legal controversies in the federal system. So if there is a dispute related to federal law, for example, you would actually end up in a federal district court, which again, as I mentioned, is a trial court. Also within the federal court system, we have courts of appeal. And that's where if you lose at the trial level, you can actually appeal. Normally what happens is the courts of appeal review orders of certain administrative agencies and also hear the appeals from the district courts, which again, as I mentioned, they're trial courts. The main thing with courts of appeal to keep in mind is you do not get to try your case again. You only get one shot at it. You try your case once, and that's at the district court or trial court level. Courts of appeal, and I'll talk a little bit more when we go into a little bit more detail into these types of courts, but all they're looking for are mistakes of law that the trial court judge would have made during the trial. That, in essence, is what an appeal is. So let's go ahead and talk a little bit more about the courts of appeal. So what they do is they examine the record of a case on appeal and then determine whether the trial court committed what's called prejudicial error. When we're talking about examining the record, normally what happens is during a trial, there's a court reporter. The court reporter is actually typing down every single word that the parties and the judges are saying. And so that gets transcribed into, in essence, the product is a transcript. And so that transcript, along with any documents that were admitted as evidence, actually gets submitted to the courts of appeal, and that's what they review, and that's where they look for any errors or mistakes that the judge would have made. And what do we mean by error? Well, I'm sure most of you have seen movies, TV shows, and so forth, where there's a trial or there's a hearing, and then the attorney will be questioning the witness, and the other attorney will actually be objecting, right? So you'll hear objection hearsay, objection foundation, objection asked and answered. Those are some of the evidentiary objections that parties make. At that point, the judge actually decides. So, in other words, what a lawyer does by objecting is they're telling the judge, hey, there's an error, there's a mistake that's being made, a legal mistake. The other side is asking an improper question. The other side is attempting to admit a document improperly, and by improperly we mean against the rules of evidence. The rules of evidence provide exactly how testimony is to be taken, how the questions are to be asked, how you introduce certain documents into evidence. And if those rules are not followed, then the attorney needs to object. So in other words, you're bringing it to the court's attention that a mistake is being made. And so then the judge gets to decide whether you're right or you're not. So if the judge agrees with your objection, the judge will say sustained. That means that they agree. So that, for example, if you're trying to introduce a document improperly and the judge sustains the other party's objection, you cannot introduce that document into evidence. So the jury never gets to see that document. If you're asking a question improperly and it's sustained, it means that the witness does not have to answer that question. The opposite of that is overruled. Overruled basically means that the judge disagrees with the party raising the objection and believes that a mistake is not being made, that a document is properly being introduced, that a question is properly being asked of a witness. And so when you appeal, that is what a court of appeal is trying to decide. The trial judge, when he or she was ruling on objections, did he or she make the right decision? And if not, then the next thing they look at is, was it prejudicial error? In other words, was it a mistake that somehow affected the outcome of the trial? If it's what we call harmless error, then it really doesn't matter. Even though the court may have gotten it wrong, it really didn't affect the outcome, so it doesn't matter. If it's prejudicial error, then really that means that the judge made a mistake and the outcome of the trial is or was affected. And the penalty for that can be severe, meaning that the appellate court can actually send it back to the trial court and say you have to retry the case. So now you try the case with a new jury is the way that works. So prejudicial error is pretty bad. It can be very expensive for the parties, right? As I mentioned, litigation is very expensive. So if you have to retry a case, that's not a good thing. Just to give you guys a brief idea or an overview here, to litigate in Florida most disputes, if you take it all the way to trial, it'll take you anywhere between 1.5 to 3 years is about the norm, depending on how many parties, depending on the size of the dispute. And you're talking about anywhere between, on the low end, $50,000, on the high end, $250,000, $300,000, actually a little bit more than that. About $200,000, $150,000, $200,000 is about the norm. That's about the average. If you have much bigger trials, much longer trials, then the attorney's fees are going to be significantly higher. My firm was just involved in an 11-week trial last summer, and the attorney's fees for not just the trial, but the entire case. This was a very complicated case that took a very long time. It was in the court system for about 9 years. That's extremely unusual, but due to the complexity of the case and the number of parties and so forth, it was a construction defect case that was very complicated. A lot of experts that were involved. But to give you an idea, we represented the plaintiff. The plaintiff spent about $2.5 million in attorney's fees. That's just to give you an idea of the cost of litigation. So not everybody can afford that. So you definitely don't want to be in a situation where you retry the case. So as the slide says here, the appellate court will reverse or modify the judgment, and if necessary, remand it, send it back to the lower court for further proceedings, which could include a new trial. Now, again, that's not good news usually. If no prejudicial error exists, as I mentioned, if it's harmless error, then the appellate court will affirm the decision of the lower court. In other words, they'll issue an opinion, usually saying, hey, there was a mistake, but it didn't affect the outcome, so too bad, right? It doesn't matter. Within the federal courts, the highest court of appeal is the Supreme Court, and it's the nation's highest court. The principal function is to review the decisions of the federal courts of appeal and also the decisions of the highest state courts. Usually the highest state courts are also called Supreme Courts, but that's not always the case. There are 13 appellate circuits at the federal level, and they're divided geographically. So, for example, at the federal level, the Court of Appeal for our geographic district is in Atlanta, Georgia. We're in the 11th Circuit Court of Appeals. So if you were in federal court and you were filing an appeal and you had to go argue, that would take place in Atlanta, Georgia. There are also special courts. Special courts have jurisdiction, and what we mean by jurisdiction is the authority that's granted to the courts to hear, decide, and rule on certain types of cases. So there are certain courts that have jurisdiction over cases in particular areas of federal law. So for example, the U.S. Court of Federal Claims. So those are usually contractual disputes with the government. That's where you would go. You would go to that specialized court. If you have a dispute with the IRS, you would go to the United States Tax Court. So those are specialized courts. Bankruptcy courts as well. Bankruptcy courts, the closest one to us is here in Fort Myers. Bankruptcy is always federal in nature, so you'll end up in federal court. And as I mentioned, the closest trial court, federal trial court to us is in Fort Myers. And obviously the U.S. Court of Appeals for the Federal Circuit as well is also a specialized court. So here's a slide that actually provides a pretty good overview of the federal judicial system. The highest court, I'm going to use my arrow here, is the U.S. Supreme Court. That is the highest court in the land. There are also Supreme Courts in several states. They're not always called Supreme, that's why the slide calls it highest state courts. Then we have, below the Supreme Court, we have U.S. Courts of Appeal. There are also many administrative agencies. We'll talk a little bit more about administrative agencies and administrative law. And within the U.S. Courts of Appeals, or not within, but below that, we have U.S. District Courts. And again, those are the trial courts, the federal trial courts. And we have tax court and bankruptcy courts. There's U.S. Court of Appeals for the Federal Circuit that reports to the Supreme Court, and also the Court of Federal Claims, Patent and Trademark Office, and the Court of International Trade, which actually reports to the U.S. Court of Appeals for the Federal Circuit. So for example, if you're involved in a patent or trademark dispute, you'd be in the Court of Federal Claims, in particular if that was related to the government. And then if you wanted to appeal that decision, let's say you lost, and you wanted to appeal, you would appeal to the U.S. Court of Appeals for the Federal Circuit. And if you lost that and you wanted to appeal, then your next appeal would be to the U.S. Supreme Court. And with federal district courts, here are the trial courts. We start at the bottom: trial courts, tax courts, bankruptcy courts. If you lose in those courts and you want to appeal, you'd be appealing to the U.S. Court of Appeals. And then if you lost there, you would appeal to the U.S. Supreme Court. If you lose at the highest state level, right, you appeal to the U.S. Supreme Court. And if you lose an administrative decision, you would appeal that to the U.S. Court of Appeals. So it's a little bit of a appellate hierarchy. So it kind of tells you when you appeal, which courts you'd be appealing to, and it's based on where you're at, the type of court that you're litigating or that your dispute is in. So that's a brief overview of the federal court system. We've oversimplified it. And we have a parallel state court system. Every state has their own state courts, and they're organized in fairly the same manner. We start off with inferior trial courts. Those hear minor criminal cases such as traffic violations. For example, here in Florida, we actually have traffic court. So if you are fighting a ticket, you go to traffic court. So those are inferior trial courts. And we call them inferior courts because they deal with minor criminal offenses, and a traffic offense is a criminal offense. It's a minor one, but it's a criminal offense. And also, these inferior trial courts deal with civil cases that involve small amounts of money. They conduct preliminary hearings in more serious criminal cases sometimes. Another example of an inferior trial court in Florida would be small claims court. So in Florida, if you have a dispute that's $5,000 or less, you would go to small claims court. And the good thing about small claims court is you don't need a lawyer. The rules of evidence are relaxed. The rules of civil procedure are relaxed. So really, they're what we call the people's court, because you don't need a lawyer. You can represent yourself, and usually these small disputes can be easily resolved through these courts. Then we have the actual trial courts. They have general jurisdiction over civil and criminal cases. In Florida, we actually break the trial courts into two parts or two levels. We have county courts, which have jurisdiction of cases or disputes that range between $5,000 and $15,000. So for example, if your dispute is too large for small claims, if it's over $5,000 but less than $15,000, you go to county court. If your dispute is over $15,000, then you litigate in what we call circuit court here in Florida. The circuit courts in Florida are the highest trial courts in the state, and the state is divided into 20 judicial circuits. In Collier and Lee, we are in the 20th judicial circuit, and so we have both small claims, county courts, and civil circuit courts within our state court trial system. There are also special courts within our state court system. So for an example, these are trial courts that have a particular emphasis or a particular expertise. So for example, probate courts in Florida. We have probate courts. So if you die and you have a will and the will is contested, if there's any dispute related to wills or trusts or estates, you will usually end up in probate court. In Florida, we also have family courts. So for example, if you have adoption hearings, if you're getting divorced, then you'd be going to family court. So those are special trial courts that only hear or entertain those types of cases. So it's almost like a specialty that they have. At the state level, we also have courts of appeal. They include one or two levels. The highest court's decisions are final, except in those cases that are reviewed by the U.S. Supreme Court. So in Florida here, we really are no different. We do have two levels. The first level are what we call the district courts of appeal. And in Florida, there are 5 district courts of appeal. We are in the second in this area. The district courts of appeal are divided geographically. And again, we're in the second. And the seat or the office for the second district court of appeal is in Lakeland, Florida. And the highest appellate court in the state is the Florida Supreme Court, which has its seat or office in Tallahassee. So here's a brief overview then of the state court system. So you start off in the inferior trial courts, for example. If you're in small claims, that's where you would start. The next level would be the trial courts. The next level above that would be the intermediate appellate court. So for example, if you lost your trial either at an inferior trial court or at an actual trial court, then you would bring your appeal over to the intermediate appellate court. There's also these special courts that we talked about here, right? So the probate court or the family law court, if you lost your trial there, you would also appeal to the intermediate appellate court. In our case, geographically, you'd be appealing to the Florida's Second District Court of Appeal. And then above that is the State Supreme Court. In our case, the Florida Supreme Court. That would be your final stop if you wanted to appeal. Now, we'll talk a little bit more about jurisdiction there, but the Supreme Court, whether it's the United States Supreme Court or the Florida Supreme Court, do not have to take your case. There are certain cases that they have to take, but they're courts of limited jurisdiction. So what that means is that there's only very few types of cases that can be brought in front of them as a first instance. All the other cases come up on appeal. In other words, they've already been decided by another court, and they are really just a court of appeal that's going to review the look for error. And these courts, the Supreme Court, decides the cases that they take. So they don't have to take your case. If they don't want to, they can deny taking your case. So let's talk a little bit about jurisdiction. I know we've mentioned it. I talked a little bit about it, but it's a very, very important concept from a legal perspective. So jurisdiction simply means the power or the authority that a court has to hear and decide a given case. And the authority is usually derived either from a statute or from the Constitution itself. So that's where the courts get this authority. Within jurisdiction, we have something called subject matter jurisdiction, which is the authority of a court to decide a particular kind of case. So for example, a contract dispute would be a particular kind of case. So one of the first things that a court would need to do is figure out, hey, is that the type of case that we can actually entertain or take, right? So for example, if you're in a probate court, or let's make it even simpler, if you're in a family law court and you're trying to bring a contract dispute, the family law court is not going to have jurisdiction. They're going to say, hey, we only deal with family law issues. You have to go to a different court. So that's what we mean by subject matter jurisdiction, is that the court has to have the authority to decide, to hear and decide the particular type of case that you're trying to bring before them. There is a little bit of a difference when we're talking about federal jurisdiction or state court jurisdiction. Remember, we have this dual court system, so we have to analyze and understand both the federal and the state. So when we're talking about federal jurisdiction, federal courts have exclusive or sole jurisdiction over federal crimes, bankruptcy, antitrust, patent, trademark, copyright, and other specified types of cases. Usually, if you're dealing with a violation of federal law, then you have to sue in federal court. We have that, we call that legally that's called a federal question. A federal question simply means a dispute regarding a federal law. So that's one way that you would end up in federal court. State jurisdiction is a little bit different. State courts have exclusive jurisdiction over all matters to which the federal judicial power does not reach. And so we'll talk a little bit more about jurisdiction as well, and in particular the difference between federal and state jurisdiction. So here's a little diagram here that kind of talks about some of the areas where federal courts have exclusive jurisdiction. And again, there's 8 items here that we've outlined. And then there are areas where outside of those 8 enumerated areas, then state courts may have exclusive jurisdiction depending on the matter, depending on the dispute. But there is an area of overlap. And where we have that overlap between federal court jurisdiction and state court jurisdiction, we call that concurrent jurisdiction. In other words, many times you can bring some of these cases either in federal court or in state court. The reason why we say concurrent jurisdiction is, for example, if you have a federal question, so in other words, it's a violation of federal law. If it's not one of these 8 specifically enumerated areas where federal courts have exclusive jurisdiction, if you're outside of that, you may sue in federal court if you want to, or you could also sue in state court, and that's why we call that concurrent jurisdiction. The plaintiff, the person bringing the claim or the dispute, decides. They get to decide where they file. We also have something called diversity of citizenship that only applies to federal court. And I have a slide here that talks a little bit more about that type of jurisdiction, so I'll say that for later. So here's another chart. Again, this is all in your book. And by the way, I do post these slides on Canvas. So if you want to use these to review, these are good aids to review. Please don't rely on the slides for the exam. The slides are just a tool for me to kind of cover the material and touch on the main points, and usually some of the more complicated points that you may not pick up on your own from reading. So even though it may not be on the slide, it may be on the exam. As long as it's in the book, it's fair game. So don't rely on the PowerPoints to study for the exam, but definitely you can use it as a tool to review. So here's a good slide again. It's in your book where it talks about the types of jurisdiction, the courts, the substantive law that's applied, and the procedural law that's applied. And we'll talk a little bit more about substantive law and procedural law as well in a little bit here. Actually, I think I'll take advantage of doing that right now. A substantive law is a law, just like the word says, right? It's a law that has substance. In other words, if a law creates rights, duties, and obligations, it's a substantive law. Most laws that you're familiar with, what you call law, they're usually substantive in nature. Procedural law, on the other hand, are those laws that, just like the name implies, deal with procedure. So the process, the rules. So for example, let's say you and I enter into a contract and you breach the contract. Well, that would be a breach of substantive law. The contract law is substantive law. But the process as to how I file a lawsuit, once you're served with a lawsuit, how long do you have to respond? What should your response contain? All those types of things that we call civil procedure, that's part of procedural law. I know earlier I talked about objections and the rules of evidence, what documents can be introduced and so forth. That is also procedural law, the rules of evidence. So again, those tell the judge, the attorneys, how they're supposed to do things. So that's the difference between substantive law and procedural law. So depending on the type of court, is the type of law that's applied. And again, there's a slide here that really covers this pretty well. If you have any questions, I know some of these issues are complicated. So when we're talking about substantive law, procedural law, what do we mean by federal substantive and federal procedural? And, for example, if you have concurrent federal question jurisdiction and you're in federal court, it may be that federal substantive law applies and state procedural law applies. So those, I know that can get a little bit complicated, and I'm happy to discuss that one-on-one with you if you have any questions. Please feel free to see me during my office hours if you want me to explain any of these areas in more detail. So that was subject matter jurisdiction. The court also needs to have jurisdiction over the parties, what we call in personam jurisdiction. So that's really the power of a court to bind the parties to a suit. In other words, the power of the court to bring the person before the court and issue a judgment that's going to be binding on both parties. So again, this is called in personam jurisdiction, which is jurisdiction based upon claims against a person, which is in contrast to jurisdiction over the person's property, which we call in rem, I-N-R-E-M, in rem jurisdiction. An example of in rem jurisdiction in Florida would be, trying to think of one here, a foreclosure proceeding, for example, would be in rem, right? Because the court needs to have jurisdiction over the property, right? Because we're foreclosing on the property. So that would be an example of in rem jurisdiction. Here it is. I didn't realize it when it was in my slide, but it's jurisdiction based on claims against property, and I already gave an example. There's also something called attachment jurisdiction, and that's jurisdiction over defendant's property to obtain payments not related to the property. So for example, if you're a landlord and there's a judgment against you, and let's say I'm the holder of the judgment, so I won a lawsuit against you and I have a judgment, I can collect on the rents from your property. So the rents that your tenants pay you, I can actually collect on that, and that's called attachment jurisdiction. So that would be an example of that. Also, an important concept when you're suing or in litigation is the concept of venue. So not only do you need jurisdiction, but you also need venue. Venue is the geographical area in which a lawsuit should be brought. So in other words, if you and I get into an accident in Collier County and you live in Collier County, I can't sue you in Georgia, right? That would be improper venue. Usually the proper venue is the county in which the defendant, the person being sued, resides or lives, or if it's an entity, the county where the entity has its principal place of business, its main office. Or venue can also be proper in the county where the cause of action accrued. So for example, if you and I get into a car accident, the county where the accident occurred, that would be proper venue. If you and I enter into a contract and you breach the contract, so the county where the contract was breached is where venue would be proper. So usually in my example in a contract, let's say that you have a promissory note, you owe me money, and you're supposed to make regular payments, right? Let's say monthly payments, and you miss a couple of those payments and you just simply stop paying. If the promissory note says that you had to pay me here in Collier County, then venue would be proper in Collier County because that's where the breach occurred, right? You were supposed to pay me in Collier County and you didn't. So that's where venue would be proper. So those are examples of where venue would be proper. Excuse me. So again, when we're talking about the concept of jurisdiction, we have two types. One is in yellow there, that's the subject matter jurisdiction. And we have three types of subject matter jurisdiction. It could be federal, it could be state, or it could be concurrent. We also need jurisdiction over the parties. It could be in rem, dealing with property. It could be personal, or it could be quasi in rem, like attachments, for example, would be quasi in rem. Under personal jurisdiction, that is where the defendant has to be present, where the defendant resides is the proper way, proper place. And there's also something called long-arm statutes. So basically, the way long-arm statutes work is that if you are not a resident, let me give you an example. It's going to be the easiest way to describe this. So let's assume that you live in California and you're visiting Florida, but you own a house here in Florida. You come on a regular basis, but your main residence, your homestead, is in California. And you're driving your car and we get into an accident. Okay? So under that particular set of circumstances, I could actually sue you in Florida because you have a house in Florida, because you come here often, and because you were driving a car in Florida. So the idea is it would not be unfair for me to sue you in Florida. Now, if, for example, you and I enter into a contract, you live in Georgia, I live in Florida, you breach the contract, and I sue you in Alaska. That would not be proper because that's not, what's the connection to Alaska, right? Let's assume neither one of us has any connection to Alaska. The only reason why I want to sue you in Alaska is because I know that it's going to be expensive and difficult for you to go there, right? Let's assume I have a lot of money, so for me, I don't really care. It's not going to be hard for me to do it, but I know that you can't do it. Well, the law is fair, right? The law tries to do what's right, and so the law will look at the overall situation and say, hey, really, you don't have any contacts with Alaska. You don't live there. You don't have any property. Maybe, in fact, you've never even been there. So how can you get sued in Alaska? You can't. So that's what we mean by long-arm statutes. If you are not a resident of Florida, and I'm going to use Florida as an example, it could be any state. Most states, almost every state that I'm aware of, has some type of long-arm statute. So what long-arm statutes are is the ability for a local court to obtain jurisdiction over a person that lives outside the state. So just because a person lives outside of Florida doesn't mean I can't sue them in Florida. It just means that I have to comply with the requirements of the long-arm statute. There's something called minimum contacts. That's the test that's usually used to determine whether the long-arm statute will apply. So, for example, in order for me to sue you in Florida, you have to have some connection to Florida, and that's why we call minimum contacts. So some of the things that the courts will look at is, do you own a house in Florida? How often do you come to Florida? Do you have a business in Florida? Did the breach, if we're talking about breach of contract, did that occur in Florida? The more connection you have to Florida, the more likely I can sue you in Florida. So it's almost like a sliding scale, right? If you have a lot of contacts, it's a very easy decision. If you only come here every once in a while, you don't have a business, you don't have a house, you don't have a bank account here, then it's less likely that I can sue you here in Florida. Does that mean that I can't sue you? No, I can, but I got to sue you in the state where you live, right? So again, we're looking at just the issue of fairness, and we don't want people to take advantage of the system. So that's what long-arm statutes are, and that's how they work. So let's talk a little bit about civil procedure. Civil disputes, and we didn't have a chance really to talk too much about the distinction, but there is a distinction between civil and criminal, right? There are two different types of things. Criminal would obviously be any type of violation against the state. Civil is any dispute between two private individuals or two entities or an individual and an entity. So civil disputes that enter the judicial system must follow the rules of civil procedure. So again, the rules of civil procedure is procedural law, right? What we discussed a little bit. So these are rules that are designed to resolve the dispute justly, promptly, and inexpensively. I'll disagree a little bit with the inexpensively part. Litigation is actually very expensive, and I don't really think it matters too much where you litigate. It can be a very expensive process, so I'm not sure I agree with that. But the rules are designed to reduce the cost. I think if we didn't have the rules, it'd be a lot more expensive. But they do tell you when you can request documents, how you request documents, when can you depose somebody, how do you depose the person, what are the time frames when you need to respond, how do you set a hearing. Those are the types of things that the rules of civil procedure deal with. So let's start off with a lawsuit. We start off with something called the pleadings. This is the first document really in a lawsuit. It's a series of statements that give notice and establish the issues of fact and law presented and disputed. So, for example, the plaintiff would file a complaint with the court. That's an initial pleading by the plaintiff that, in essence, tells the court what the problem is, right? Somebody, you breached the contract. So, in other words, you got to tell the court, hey, we had a valid contract. Here's a copy of the contract. The person breached it. Here's how they breached it. And I've been damaged. And here's how I've been damaged. So those are the types of things that you would find in the complaint. Along with that, the clerk of court will issue a summons. That's a notice that's given to inform the other person, the person being sued, the defendant, that a lawsuit has been filed against him or her. Then the next pleading is an answer. So if you're the defendant and you receive a complaint, the next step in the process would be for you to file an answer. And that's the defendant's pleading in response to the plaintiff's complaint. So in other words, you're going to look at the complaint and your answer is likely going to say denied, denied, denied. I deny all these allegations. And any defenses that you may have, you also want to raise in the complaint. So again, I'm going over this very briefly. I don't want to get too technical about it. But in Florida, just to give you an idea, right, talking about the rules of civil procedure, the rules of civil procedure say that a defendant has to answer the complaint within 20 days of receiving the complaint. Otherwise, a default is entered. If a default is entered, it simply means you lost. So you definitely don't want that to happen. Another pleading is a reply. That is the plaintiff's pleading in response to the defendant's answer. So for example, if the defendant raises affirmative defenses, you may deny those defenses or tell the court that those defenses don't apply and the reason why you believe those do not apply. Then the next step in the process is pretrial procedure. So that's the process of requiring the parties to disclose what evidence is available to prove the disputed facts. And it's designed to encourage settlement of the cases or to make the trial more efficient. We call this usually, in Florida, we call it the discovery process. So inside the discovery process, you can ask for documents. You can send written questions to the other side that they have to answer under oath. You can depose the person, meaning they have to show up in person, and under oath, you get to ask them questions. And everything that they say gets transcribed, right? There's a transcript, just like a trial. And you can use that against the person in trial. So, what's interesting about the discovery process is a lot of times I think it's funny when I watch a movie or a show where somebody just pulls out a magic document that no one's ever seen before that wins the case for them. Or there's a witness that just comes out of the blue that nobody knew about, that has the smoking gun testimony for one of the parties to win. That never happens in real life. If it does, you have a very bad lawyer. By the time I get to trial, I know exactly who your witnesses are. I know exactly what they're going to say because I've deposed them and I've asked them. I know exactly what documents you're going to use because not only have I requested them, but we've exchanged them. So you know which documents I'm going to use. You know which witnesses I'm going to call. So really, trial is a show more than anything else. There are no surprises. Now, just like with life, right? A witness can change their testimony, or people get nervous and don't say the right thing. Those things do happen. But overall, by the time we get to trial, I know everything about your case and you know everything about mine. So it's not really, a trial's not really to prove something that nobody knows anything about. So really, trial is more an opportunity for me to present my case to the jury who's never heard my side of the story or never seen the documents, and for the other side to do the same. But as far as the lawyers and the parties that are involved, we already know exactly what the other side's going to say. For the most part, if you're a good attorney, you know what your opponent's going to say. There is something called judgment on the pleadings. I'm not going to get into a lot of detail about that. I'll let you read about that in the book. But these are all, it's a type of motion that can be used to challenge the pleadings. And you could win on that, but usually most courts, if you do win, the court will allow you to amend or fix whatever mistake you made. That's usually how that works. Discovery I already talked about. Pretrial conference, this usually happens a few weeks before trial, and it's a conference between the judge and the attorneys, really to simplify the issues that are in dispute, to attempt to settle the dispute without a trial, and also to come up with some order, right? Meaning, here's how the trial is going to take place, here's how long. It's really a lot of administrative issues related to the trial. So that's what happens at a pretrial conference. Summary judgment, that's another type of motion. It's a final ruling by the judge in favor of one party based on the evidence disclosed by discovery. Summary judgment may or may not be granted. I've had some summary judgment motions granted. In fact, I won one very recently, a very big one, but it's unusual. Most of the time, judges will not grant summary judgment. Usually what happens is if a judge denies summary judgment, then you simply go to trial. So that's why a lot of judges will simply deny summary judgment. If they do grant it, then that means you win. So the case is over. So that is a big issue. Now in summary judgment, the only thing that the court can rule on are issues of law. So the facts can't be in dispute. If there's something that's disputed, some type of fact that's in dispute, then the judge can't grant summary judgment. That's why many times they're not granted. Then the last step really is trial. So if you don't get it resolved before trial, you actually make it to trial, and it determines the facts and the outcome of the case. You start off with jury selection. Each party has an unlimited number of challenges for cause and a limited number of what we call peremptory challenges. For cause, it could mean, for example, if a juror is biased. So that would be for cause. And peremptory challenges, that's what you determine at the pretrial conference, how many of those challenges each side is going to have. You may have 3, 4, 5, depending on many different factors. But what that means is you could use those to really get rid of any juror that you don't like for any reason. So, it may be that you don't feel that a particular juror is going to be sympathetic towards your client, and you could simply use one of those challenges to strike it. What you can't use it for is to discriminate. So you can't strike somebody because of their sex or their religion or their color. That's an improper way of using that. Conduct of trial. You start off trial with opening statements. The plaintiff always goes first, followed by the defendant. Then you have direct examination. So in other words, the plaintiff calls their witnesses. Then when you have cross-examination, so after you call your first witness, then the defense gets to cross-examine your witness. And then once you go through all of your witnesses, then the defense gets to put on their witnesses, and you as the plaintiff get to cross-examine their witnesses. Once all of that is done, then you have closing arguments. In Florida, again, the plaintiff goes first, the defendant goes second, and the plaintiff has the last word. They get a rebuttal. The reason for that is that the plaintiff has the burden of proof. So because they have the burden of proof, they have to prove their case, they go first and last. They have the final word. After trial, there could be something called a directed verdict. That's before the jury makes a ruling. And what that is, it's a final ruling by the judge in favor of one party based on the evidence presented at trial. It may be that your case is so strong that you win on directed verdict. An example of that would be, let's say I'm the plaintiff and I have the burden of proof. And if I didn't meet that burden, if the testimony that I put into evidence through my witnesses and the documents that I presented is not enough, right, to satisfy that standard, and the judge believes that it's not enough, then the judge will usually grant a directed verdict and it won't go to the jury. The jury won't get to make that decision. Most directed verdicts are denied. Once that happens, then the jury gets their instructions. The judge actually gives the jury particular rules of law that applies to the case. And the attorneys actually have input into those jury instructions. And that's all done before the trial even begins. Then at the very end, you have the actual verdict. That's the jury's decision based on the facts that they heard, and they determine who's right and who's wrong. After that, you can still have motions challenging the verdict. So there's several motions you could use. There are motions for new trial. So for example, if you believe that the judge made a really bad mistake, you can ask for a new trial. You can also ask for a judgment notwithstanding the verdict. In other words, if the evidence was so strongly in your favor, yet the jury ruled against you, and there's no way a reasonable person would ever have ruled the way the jury ruled, that's when a motion for a judgment notwithstanding the verdict would be granted. Those are very, very rare. I've never seen one granted personally. Those are usually denied. And after the trial is over, then you have the right to appeal. It determines whether the trial court committed prejudicial error or not. In Florida, remember, right, we're going back to these rules of procedure. You have 30 days to file your notice of appeal. If you don't do it within the 30 days, you cannot appeal. Then last, you have enforcement. So once you have a judgment, so if you have an unpaid judgment, there are several mechanisms you can use to try and collect on that judgment. A writ of execution is one, where you ask the sheriff to seize personal property of the defendant. You can also ask for garnishment. So for example, you can garnish a person's bank account. You could garnish their wages. There's limitations to that. Florida is actually pretty good at protecting debtors. So there's a lot of protections in Florida, but I'm not going to get into those right now. But there are a lot of mechanisms that can be used to try and collect on a judgment. Here is a slide then that really talks about the stages in civil procedure. You start off with your pleadings, and then on the yellow side there you could see some of what the pleadings are: the complaint, the answer, the reply. On the green side, it tells you what happens at that stage. So at the pleading stage, you determine what facts are in dispute. Then you move on to the pretrial procedures, which includes discovery, summary judgment, and that's where you discover what evidence there is to prove. So I'll let you read through each one of those. This is actually a very, very good summary of the stages, some of the documents and motions, and what happens is in green. All right, so let's move into alternative dispute resolution, or ADR. As I mentioned, litigation is extremely expensive. If you can avoid it, great. That's usually the best mechanism that you have. There's a couple of different types of ADR. One is arbitration. It's a non-judicial proceeding in which a neutral party selected by the disputants renders a binding decision called an award. So in other words, the two parties agreed that a neutral, known as an arbitrator, gets to, in essence, decide the case. And that arbitrator's decision is going to be binding. The advantage to arbitration is that, for the most part, it moves a lot quicker than litigation. I mean, you could resolve your dispute, if it's not complicated, in 3 to 6 months. So it moves a lot quicker, which obviously is less expensive. Discovery is very limited. The rules of procedure are relaxed. The rules of evidence are relaxed. So those are some of the advantages. There's also disadvantages. I'm not going to go into a lot of those, but a lot of times not having the rules and having the process go too quickly can also be a disadvantage. You also have something that the book here and the slide calls conciliation, which is a non-binding process in which a third party acts as an intermediary between the disputing parties. In Florida, we call that mediation. And in fact, in Florida, before you can get to trial, you have to go through mediation. Just like it says, the process is non-binding, so the mediator does not make a decision. So an arbitrator makes decisions, a mediator does not. All the mediator does is the mediator goes back and forth between the parties and tries to find some common ground. And usually what happens, it's an all-day process. There are offers that are made that go back and forth. And again, good mediators are able to show or point the weaknesses in the arguments of both sides and really encourages both sides to settle. The good thing about mediation, and about 90% of cases in Florida settle, only about 10% go to trial. So most of them actually settle, and most settle at mediation. The reason for that is that with mediation, you create a certain outcome. As soon as you step out of that mediation, you know exactly what the outcome is, and you participated in that process. You can get as creative as you want. You can craft any type of solution that you want. If you go to trial, it's outside of your control. The jury is going to make a decision for you, whether you're right, you're wrong. You never know the type of jury you're going to get. I've had cases that I thought I was going to win, I was sure I was going to win, that I lost. And I had cases that, in my mind, I was like, there's no way I'll ever win this. I've won. So, and every trial lawyer will give you that same opinion. We've all been in that situation. So you don't know. So whenever a client tells me what's going to happen, I have no idea. Once you go to trial, I have no idea. I have no idea what a judge is going to do, what a jury is going to do. So that's the advantage of mediation, that the parties are in control. They decide the process. They decide if they want to resolve it and how. So that's the reason why most of these cases settle, and the advantage to it. So these are some slide that really has some of the advantages and disadvantages of court, what we call court adjudication. That's really a fancy word for trial. We have arbitration, and then we have mediation and conciliation. So again, some of the advantages and disadvantages there. So I'll let you guys read through each of those. Again, any questions about any of these slides or any of these concepts? I know it's tough when I'm just lecturing here. We're not really seeing each other, so I can't tell if you're getting it, not getting it. In a classroom setting, I can tell if you're lost, not lost, and I know what I need to spend more time on. Here I can't, because I can't see you. So I'm just trying to cover as much of the material as I can. So if you have any questions, please ask when we do meet in person. I know a lot of times it's a lot easier when we're in person. So again, we talked about mediation, which is also conciliation. They're really, the book makes a distinction here, but it really is the same thing: conciliation, mediation. In fact, in Florida, we don't even have a conciliation process; it's just a mediation. There's also something called the mini trial. And again, in Florida, we don't see a lot of that. It can happen. It's a non-binding process in which attorneys for the disputing parties, usually corporations, present evidence to managers of the disputing parties and a neutral third party, after which the managers attempt to negotiate a settlement in consultation with a third party. So this is almost a hybrid model where it's almost like an arbitration, but it's not binding, and it actually leads to negotiations. So in that respect, it's like mediation. The advantage of a mini trial really is that, especially the managers are present, you're trying to show them the weakness of their case, and why they would want to resolve it and not take it to trial. A lot of times when you prepare for a trial and you start putting the witnesses on the stand and you start going through the documents, a lot of times you could see things that maybe you didn't see before. Maybe your witnesses aren't as good as you thought they were. Maybe your documents aren't as strong as you thought they were. So that's what this mini trial process allows you to do. I've never been involved in one here in Florida. Again, we don't have many of these, at least not in Florida. We have something similar to that, where we use private judges, and then really the difference is that they are actual trials and they are binding, but you do it in front of a private retired judge. The reason why you do that is because the process is a lot quicker, and it's usually less expensive, and you can also create your own set of rules, right? You could tell the judge, in that particular case, the retired judge, right? You could say, look, the rules of evidence are not going to apply, or they're only going to apply, they're going to have limited applicability. So that's the advantage of doing it that way. And you can usually get it to a final resolution quicker. So that I have seen, and that I am more familiar with. And that's really what some of these are here. I mean, all of these are really interrelated. Summary jury trial is really a mock trial followed by negotiations. So that's really almost a take on this mini trial process. So summary jury trial is very similar. You actually go through a trial and then you go through negotiations. And again, the idea with that is you're going to show the other side how weak their case really is and how good you're going to do if you actually go through a full-blown trial. So again, the idea is to encourage settlement. Negotiation, that's probably the easiest, and that's usually what should be happening anyway. Before you ever get to litigation, you should always attempt negotiation, which is consensual bargaining, in which the parties attempt to reach an agreement resolving their dispute without the involvement of third parties. So in other words, no attorneys, no mediators, no arbitrators. Those are just the parties saying, look, you wronged me. Here's what the contract says. Here's what you should have done. You didn't do this. How can we work this out? That's usually the cheapest way. Smart business people will usually attempt to do that first and only litigate if that fails. And it makes economic sense, right? Because at that point, you're really not paying attorneys. Once you get attorneys involved, the process gets out of control. It gets very expensive. It can get time consuming, very frustrating for the parties usually. So to the extent that you can negotiate the outcome, that is always going to be ideal. I always recommend, in fact, my clients, a lot of times when they come to me with a dispute, especially if it's not a major dispute, I'll always ask them, first question is, hey, have you reached out to the other side? Have you talked to them about this? A lot of times, many times we're involved in litigation and we get to the mediation process, and that's usually after the parties have spent several thousands of dollars, and we'll hear, if you only would have come to me and told me that before you filed the lawsuit, we could have worked this out. So that is a very important factor to consider. You don't want to sue just to sue. you really do want the lawsuit to be a last resort. Again, just because of the expense that's involved. Um, when you're paying your attorneys, you're going to be paying them an hourly fee, and those hours rack up very, very quickly. Um, so those are the types of things. My rate, for example, is $400 an hour. And I could very easily, writing one of these motions, I could very easily spend 10 hours. So you're paying me $4,000 just to write a motion. And that's only one part of the litigation process. If we go through a 3-day trial, for example, right? Those are 8-hour days. So that's 24 hours times 400. So you're talking about 10 grand just in the trial. Then we have all the preparation and everything else that gets involved. So you could see how it can add up very, very quickly. So negotiation's always the best. That's it for chapter 3. That's it for this week. So please make sure that you stay on top of the material. Again, I know it can be boring listening to these lectures, and especially because we don't have any interaction, no questions, no involvement, but please make sure that you stay on top of the material. You will see all of this on the exam, and unfortunately, with an online class, this is the only way we can communicate. But if you have any questions, again, I want to stress that I'm here to help you. I want you to do well. So please make sure that you let me know if you have any issues. Please make sure that you also do the homework. There are some problems for chapter 3. Those are in the agenda. You upload the answers to Canvas. And again, I'm not looking for the right or wrong answer. I'm looking for your effort. I want to see that you're putting some thought into your answers, and I do read them, even though I'm not going to grade them. I do read them, and I want to make sure that you are putting some thought into it, and that really is the only way that you're going to learn the material and that it's going to stick with you. Having said that, we'll see you next week where we actually get to meet in person. We'll cover the next couple of chapters and answer any questions that you may have. Thank you.